Hello, and welcome to my talk titled Copyright and Third-Party Code Use. This is much shorter than my original title, which was, The first rule of copyright is you do not remove the license. And the second rule of copyright is you do not remove the license. I should start with a note about who I am. First of all, I am not a lawyer, and I am definitely not your lawyer. I am a developer. So while I would like to talk to you about copyright, which is a legal issue, you should not interpret this as legal advice. This talk is intended for any developer who works with third-party code, but who has never had any instruction on how to handle licenses. Let me ask you this question. How many of you have ever copied code from Stack Exchange into your application? And how many of you also placed a copy of the Creative Commons Share-alike license in your source code repository? If you said yes to the first question and no to the second question, this talk is for you. I'm going to give you the 15-second version of this talk. If you copy code from a third party into your application, you must also copy in their license terms. And if you distribute an application that includes components from a third party, you must distribute their license terms with it, whether you copied any source code into your application or not. The first thing that you should know about copyright, and the reason I'm giving this presentation, is that free software licenses extend the right to distribute and modify software to you. However, when you distribute third-party code, you do not become the copyright holder. Only the original author, the copyright holder, can attach license terms to their work or change those terms. If you choose to distribute their work along with yours, you must also distribute their license terms, and anyone who receives your software can use the free software components under their original license terms. Why? That's always the question that comes next, right? The basic premise of free software licensing is that copyright forbids you from distributing another author's software. If they assign a license to their work that extends distribution rights to you under some conditions, then you have the choice to either abide by those conditions or not distribute their software. If you distribute it and don't abide by the conditions, then you're infringing the author's copyright, which can carry serious legal repercussions. So let's look at one license. The Apache license version 2 says that you may distribute copies if you give recipients a copy of the license and you retain copyright, patent, trademark, and attribution notices in your source code repository. Notices have to be retained at all stages of the development cycle. While you're developing code, you need to keep notices intact in the source code files and repositories, and later, when you distribute software, you need to keep the licenses with the work they cover. Now you might ask, what about other licenses? And I would give you a two-part answer to that question. First, similar requirements exist in all of the common free software licenses. Apache's license was chosen as an illustration because it's especially clear on the subject. Second, those requirements actually exist in US copyright law itself, regardless of the text of the license. So no matter what license is attached to a third-party work, you must retain any license notices regardless of how you use that work. This is an excerpt from US copyright law, which states, "No person shall remove or alter copyright management information," which it later defines as the terms and conditions for use of the work, among other things. Obviously, if you have a source code archive and you remove the license file, you've removed the copyright management information. Likewise, if you have a source code archive and you copy some or all of its original contents without the license file into a new archive, then you have also removed the copyright management information. I think we all agree that that makes sense, but let's consider a case that's less obvious and where people tend to make a mistake. If you compile third-party source code and copy only the resulting binaries into a new archive, you've removed the copyright management information. Compiling the source code is not a creative process and does not create a new work. It is the same work in a different form. It is still governed by the original license, and that license cannot be separated from the copyrighted work. Now let's look at some examples of what that looks like in practice. Many licenses allow you to use the author's work in whole or in part, and you may decide that you only need a small part of the author's work. For example, if you take a single function out of a file that had an Apache license notice, and you want to put that function into an existing file, you'd also need to take any license notice from the original file along with it. In this example, there are two license notices. The first covers the original file content, and the latter notice covers the portions that were copied in. This can be unclear to developers who come along later, so while that's typically allowed, it's often better to simply keep the third-party code in a file of its own, with the original notices intact, so that anyone who maintains this later is clear on what license applies to exactly what content. Regardless of which of those things you do, if you've imported portions of a third-party work into your application, you must also import their license file. As we move later in the development cycle to the distribution phase, we still need to keep licenses intact. Here, we're going to look at Java as an example. If you were to install OpenJDK and look at its top-level directory, you'd see a directory called legal, which contains directories describing different Java packages, each containing license information for Java and for all of the third-party code that's used in the Java distribution. Another example is GitLab. In their software installation, at the top level, they include a directory named licenses, where you can find licenses for hundreds of third-party components that are used in the GitLab application. I also want to point out that this requirement doesn't apply to only code. The same thing is true for other copyrighted work such as fonts. If you were to import free software fonts into a repository of your own, you would need to retain the license for those fonts. You should also be aware that licenses may not be immediately visible. For example, if you're looking at code that someone shared on Stack Overflow, that code should be licensed to you under the Creative Commons Share-alike license. And there are at least two risks here. First, if the person who put that code on Stack Overflow isn't actually the author of the code, if they've copied it from somewhere, then the copyright holder might be able to hold you liable for its use. For that reason alone, I advise that you don't use code from Stack Overflow directly. The other risk is that the Creative Commons Share-alike forbids you from placing any additional restrictions on the use of that code, similar to the requirement in the GPL. If you use code from Stack Overflow in a proprietary application, that might not require you to make your code available to your users, but it might invalidate any restrictions in your end-user license agreement. Now, I don't want you to walk away from this talk thinking that this is a primer on license compliance. It's not that. You can't merely keep license notices intact and believe that you're in compliance with your licensing. You need to evaluate each license independently and make sure that you can comply with all of the terms if you're going to distribute that code along with yours. But what I do want you to take away is that if you've been using third-party code without keeping license information intact, then you're not complying with the license requirements. And you should review all of the third-party code that you use to determine how to fix that. And it might be hard to identify third-party code if you didn't keep the notices intact. The other thing I want to encourage you to do is talk to the developers of the third-party code that you use. I believe that most developers will work with you to prevent or correct any potential infringement. And that is my talk. Thank you. As a sort of postscript, I want to say that I know that some of you think this is all common sense. I know that some of you think this presentation was unnecessary, and I did too, until I found a large commercial application that made liberal use of a variety of free software components and did not include any of their licenses. When I brought this problem to their attention, they didn't seem to understand exactly what problem I was describing. I started talking about that with developers that I know, friends of mine, and I learned that none of them had ever had any training regarding license handling from any employer. Naturally, XKCD had something relevant to say on this topic, and that is, there is nothing that everyone knows. Everything needs to be learned, especially the nuance of invented systems like copyright. I think a part of that is that copying is so fundamental to our use of the internet, and to our use of computers more generally, that it becomes difficult to conceive of the fact that copying is actually a legally limited activity. So I've come around to the belief that everyone needs a few minutes of talk about copyright and license requirements. If you understood all of these points already, maybe one of your coworkers doesn't, and you can give them that talk. Finally, XKCD comics are available under Creative Commons non-commercial license, and this talk and its slides are available under Creative Commons Share Alike if you'd like to use them. Thank you.